Hello, everyone. Welcome back. Time now to get you involved in the show. All week long, we've gotten questions from our viewers on Twitter, Facebook, and email. So let's get right to them. Our first question comes from Robert in Mandeville, and he has this question about the differences between at-will employees and contract employees, and what rights do you have if you fall under either one of those categories?
Well, at will, most employers are at will if you don't have a contract. If you got a contract, the contract terms would govern. But at will, they can fire you with or without cause or for a false cause. So basically, the only protections you got are under existing laws. It's like the old days with the feudal system. They had little boxes, and they would put a writ in the box, and you had to fit trespass or this or that or battery or assault, and you got to fit sexual harassment, racial discrimination, Title VII. You got to fit in one of those, whistleblowers, Sarbanes-Oxley. If you don't fit in that, you don't have any protection. Okay,
and as you were saying just not very long ago, pretty much everybody falls under that category of being an at-will employee. That's pretty much all of us,
people.
Right?
Yes.
Yeah, most people. Okay. Our next question comes from Tracy in New Orleans. She says, how can I report unsafe working conditions anonymously? This goes back to that whole whistleblower issue.
Well, what you should do is contact OSHA. They have a website. They have an office in Baton Rouge, and you can fax them a letter and ask to be anonymous. I'll tell you, it doesn't mean you're going to be anonymous the whole time, but they can breach that. But you can ask for that, and they'll try to maintain that as good as possible, as well as possible. But yeah, you can send a letter to OSHA on unsafe working conditions, and you've got to do it. There's time limits. I can't remember on that statute. I think it's 90 days or something like that.
90
it's
days
tight.
from what?
From the date it's going on or it's happening or whatever the event's happening. If there's an event, it's on a case-by-case basis. But
yeah, I would like to just add to that and kind of get back to what we were saying at the end of the last segment. Remember, if you are aware of an illegal activity going on, and Glenn, there's just never enough time to talk about these things. If you are a whistleblower and you report illegal activity that's taking place, you may end up being able to benefit because if you expose fraud, corruption, illegal activities, and the case ends up producing money, you can get a percentage of that. You want to just flesh that out for us?
Yeah, well, basically, whistleblowing is reporting illegal acts or improper acts under law. And so when you report these to law enforcement or your supervisor, each statute's different, but basically you're protected. And employees make the mistake a lot of times, especially women, single parents, they don't want to report sexual harassment or whatever because they say, oh, they're going to fire me. Well, actually, you're better protected. Once you file that complaint, in writing sworn complaint, they can't fire you. You're protected, and the employers know that. They're not going to be stupid and fire you for that. Because statistically, jury verdict research says 98% of the retaliation cases, the employee wins. So you want to file those complaints and document that. So it's any illegal activity, you can, and under some statutes you can be rewarded, you can be issued punitive damages, you can be issued under False Claims Act, a percentage of the recovery, if there's millions of dollars involved, and you report that, and you're the first one.
But we want to be very clear with Tracy. If she does know something that's going on and she does report it, maybe initially she may remain anonymous, but being realistic about it, her anonymity won't last for long.
Yeah, and let me say this also to Tracy. Most lawyers, somebody like Glenn, you can go to the Power of Attorney website. There'll be links to get you to free information, and we'll put information from Mr. McGovern's website. And you can also Google or find Mr. McGovern. Find him through our website. Find him on the internet, Glenn McGovern. And I'm betting that he'll either talk to you directly or talk to my office, and we'll give you some assistance on this, where an attorney who does employment law will give you some further insights specific to your concerns. Or if it's not you, it's one of your friends, you can put them in contact with one another. That's another suggestion. One more thing on retaliation. You may be an employee who's hurt on the job. It's a workers' compensation thing. It's not an employment discrimination thing. An employer sometimes will retaliate against you because you have dared to ask for wages while you can't work, and you're entitled to workers' compensation benefits. There's laws on Louisiana's books that say if an employer fires you because you're making a workers' compensation claim, you're asking for workers' compensation, you can get not only your workers' compensation wage benefits, medical benefits, but also penalties against that employer, including attorney fees, because the employer retaliated against you, fired you for attempting that. So there are similar laws.
When you file these complaints, really, in terms of the length of time that it could take before your case is settled or before you get any sort of restitution, I mean, people should be aware that this is something that could take a long time. I mean, they should be in it for the long haul, correct?
Right. It just depends on what court, where it's filed. It goes a little quick in federal court, but you can have appeals and that sort of thing. But like this lady here, Tracy, on OSHA, they'll jump on it. They react pretty quick, and they'll make a decision on that.
Okay, all right. Let's go to Stephen from Slidell. Here's a question. He says, can my employer drug test me without my permission?
Okay, usually most, that's governed under state law. If you're in Louisiana, most of them have it in the employment manual, whether, you know, what the rules are for drug testing, and they can do it. And then you've got other laws like workman's comp law. If you have an accident, they can drug test you. And there's certain rigorous requirements they got to meet for that drug test. So you can't just pee in a cup and they say, okay, you know,
well, so your employer can't just pop up one day and say, we want to drug test you.
No, they have to implement a policy and everything, and it's in the employee handbook. And there's a whole set. We're really good on safeguarding that.
Okay, all right, all right. Scott writes in and he says, are there any protections for gay or lesbian employees under Title VII?
Nope.
That's the short answer?
That's
and
it.
the long
You're
answer?
Out.
And the answer.
You're out. You may have, in Orleans, they have a Human Rights Commission and they have an ordinance. Your city may have an ordinance, but no, you don't have any protections right now.
Okay, all right. Did you want to add something to that?
No, just that's one of those things where there are certain things covered under Title VII, there are certain things covered under our state laws, but the gay or homosexual rights or civil rights for same-sex unions, not covered.
Not covered.
Now, you know, let me say this. If you're sexually harassed by another gay manager or whatever, that may be covered under sexual harassment because that's sexual in nature, but not because you're homosexual.
I see. And when it comes to filing those kind of complaints, do you find that people just don't know how to handle those situations or don't know what is reportable?
Yeah,
what do you find?
Most people, even, you know, educated professional persons, I'm shocked, they don't know where to go. You go to the EOC 1555 Poydras Street, that's the only one in the state, and sign a complaint. But they don't know, and also they don't know, state law is 1 year prescriptive period for torts. Under EOC, it's 300 days. So if you don't file it, if you wait longer than that, you may only have a state cause of action, and you want to get that federal cause of action. Let
me repeat that. Under the EOC rules, it's 300 days, not 365 days, 300 days. Again, go to johnredmondpoa.com and we will have that information there in case it's not clear. You don't have a pencil and paper during the show.
Okay, here's a quick question, our last one for this time. It says, social media, and this comes to us from Troy, social media such as Facebook is ubiquitous these days. Does my employer have grounds to fire me because of writings and photos taken during time off work?
Yeah, this is a real hot area that's rapidly developing now. And there's questions. It's even some employers are requiring you to give them your password so that they can check your site. And so the law is in flux. There's no cases in Louisiana on that. The only cases are on discovery. When you file a suit, can they get access to your Facebook site?
Okay, so we're running very short on time. So if an employer does ask me for my password, am I required to give it or no? Legally, do I have to do that?
There's no law on the point.
There is no law.
There's only a couple of cases, and basically they say no. And the way you have the privacy settings seems to be critical in those cases. If you've got privacy settings, the employers generally don't have access to that.
Okay, all right. Well, we have to wrap it up. We are completely out of time. That's all the time that we have. We hope that you will join us again next week, same time, same place.
Thanks, Glenn, and thanks everybody watching at home and online. Remember, you can visit our website, johnredmondpoa.com, and watch every episode of the show, as well as get all kinds of great legal information. Thanks, and we'll see you next week on LAE.